Welcome, everyone. Good afternoon. My name is Evonne Andris. It's a pleasure and honor to be here with you this afternoon to present the condo safety reforms. We'll go through our slides and then open the floor up for any questions that you may have, and you can do that through the chat function as we move through this presentation. As I mentioned, my name is Evonne Andris. I am a partner shareholder with the firm. Our firm has over 40 years of experience in construction, community association, and real estate law. We believe the best results are built on trust and working with our clients. And throughout the years, our firm has successfully handled, settled, arbitrated, and tried numerous cases. We currently represent over 800 community associations throughout South Florida and represent a diverse base in every facet of real estate matters. I joined the firm in 2012, and I currently represent condominium and HOAs and general related matters. I handle matters pertaining to the operation and management of associations, as well as some preliminary litigation before I hand those matters off to litigation teams. Today, we're going to be talking about those new updates, the condo safety reforms. Condominium safety reforms were very much in the spotlight during this past year's regular session of the Florida legislature following the unforgettable tragedy in Surfside, Florida. Though legislators could not agree on legislation pertaining to safety reforms during the regular session, they successfully were able to and implemented safety reforms during a special session that occurred over the summer. The safety reforms are split into two separate, distinct, but very important issues. The first we'll be discussing is the building safety or milestone inspections. The second is the structural reserves, and we'll focus on both of those topics today. Starting with building safety, the legislature passed Senate Bill 4D. It included and created what we are now calling a milestone inspection. Florida has now imposed a statewide structural inspection program for condominium and cooperative associations that are 3 stories or more in height. Though this specific structural inspection program has been defined and will be called the milestone inspection. Community association managers or management companies contractually hired by a condominium association that is subject to this inspection must comply with this section as directed by the board of directors. Milestone inspections must be performed by December 31st of the year in which the building reaches 30 years in age, based on the issue date of the building certificate of occupancy, and then every year, 10 years thereafter. Buildings located within 3 miles of the coastline must perform a milestone inspection by December 31st of the year in which they reach 25 years in age, and then every 10 years thereafter. Buildings with a certificate of occupancy that was issued on or before July 1st, 1992, must have their initial milestone inspection performed before December 31st of 2024. So if you are managing or you're a board member for a condominium association that is within 3 miles of the coastline, your requirement is to do a milestone inspection is when your building reaches 25 years in age and then 10 years thereafter. Anything further away than 3 miles from the coastline, your inspection requirement would be that when your building reaches 30 years of age and then every 10 years thereafter. With regard to the limitation of the 3 stories or more in height, there is discussion going on within the community of attorneys who represent condominium associations as to what defines 3 stories or more in height. There is hope that with the next legislative session, there will be clarification as to what the height means and exact specifications and specifics as to associations that may be or just reach that 3 stories in height, since it's somewhat of a subjective definition. With further regards to the milestone inspection, condominium and cooperative associations are responsible for scheduling, and the costs associated with the milestone inspection are common expenses for your association. Milestone inspection means a structural inspection of the building's load-bearing walls and the primary structural members, systems, and supports for your building. The milestone inspection must be performed by a Florida licensed engineer or architect who must attest to the life safety and adequacy of the structural components of the building. To the extent that it is reasonably possible, the inspection must determine the general structural condition of the building as it affects the safety of the building, such as the necessary maintenance, repairs, and replacements of structural components. Substantial structural deterioration is described as substantial structural distress that negatively affects the building's general structural condition and integrity. And substantial structural deterioration is what the inspectors will be looking for when they conduct their milestone inspection. The milestone inspections consist of two phases. Phase one would be the visual examination to determine if the areas of the building are habitable. If there are no signs of structural deterioration, phase two is not required. So your initial examination is a visual examination by a structural inspection specialist who will go through the building, your load, and reviewing your load-bearing walls and your primary structural systems to determine if they see any substantial structural deterioration. If there are no signs, your milestone inspection ends there. If there are signs of substantial deterioration found during phase one, then phase two would be required. Phase two will involve destructive testing or non-destructive testing at your inspector's direction. This additional inspection may be as extensive or limited as necessary to fully assess the areas of distress that were located. The architect or engineer who perform inspections must submit a sealed copy of their inspection report and findings to both the association and the appropriate local building official. Local enforcement agencies will provide buildings required to comply with the updated law, notice of the required inspection by certified mail. So your local jurisdiction, which would be the city that you are located in, is going to be required to submit to your attention a notice that you have to conduct your milestone inspection when your building reaches either the 30 years or the 25 years, depending upon its location. Upon receiving notice, condominium cooperative associations will have 180 days to complete phase one of the inspection. Certain municipalities and cities are already starting and preparing their procedures and processes for this notification, along with what they're going to require for the structural reports that are submitted to their attention. Miami Beach is having one of their first webinars or information sessions on this topic tomorrow. I know they have others that are planned, and I would assume that you'll have other municipalities and cities follow suit shortly thereafter. With regards to the reports for the structural inspection, the engineer and architect performing the report must indicate the manner and the type of the inspection. Within reasonable professional probability, the engineer or architect must describe the extent of the deterioration and then identify any recommended repairs for the association. So not only is it a report isolating and illustrating the issues and concerns with regards to the structural integrity of the building, but the architect or engineer have to also provide the association with repair protocols. The report must state, whether unsafe condition or dangerous conditions have been observed. And it must provide recommendations on any remedial preventative repairs for damaged items that are not considered substantial structural deterioration. It must also identify and describe any items that require further inspection. The association must distribute a copy of the inspector prepared summary of the inspection report to each unit owner by mail, through personal delivery, or emails for those who've consented to electronic correspondence. They must post a copy in a conspicuous location on the property, They must publish the report on their website if the association is required to have a website. Local enforcement agencies may prescribe timelines for the necessary repairs. Local ordinances may be adopted requiring repairs for substantial deterioration to commence within a specified time frame. And that again will be your local jurisdiction who direct how and when you need to make those repairs that are identified in the report. Associations must commence substantial repairs for substantial deterioration within 365 days after receiving the report, and must submit proof to appropriate local enforcement agency that the repairs have been started and commenced. Associations that fail to follow the required time frame for repairs are subject to further review by local enforcement agencies, which will determine if the building is unsafe for human occupancy. A copy of the report is considered an official record, is open to inspection by the association's members and authorized representatives, and it must be kept by the association for 15 years, extending that 7-year period that we all know in condominium associations' official records. Renters are able to inspect and may also copy the inspection reports. Moving to the second prong of the recent condominium reform or safety reforms is the structural integrity reserve study. Reserves have been changed and dramatically revised by this most recent legislative update and Senate Bill 4D. The legislature has created the Structural Integrity Reserve Study. This reserve study must now be completed for buildings 3 stories or higher in height every 10 years, and it must be completed by December 31st, 2024 for associations existing on or before July 1st, 2022, which are controlled by unit owners. Developers must perform this study before turning the association over to unit owners. So not only does the developer have to do their standard reserve study or their turnover audit for an association, but they now also have to prepare and have a structural integrity reserve study performed. The reserve study may be performed by any person qualified to perform such study. However, the visual inspection portion of the study must be performed by a licensed engineer or architect. That's causing a little bit of rumbling within the reserve study community. As some of you may know, or that you've experienced, reserve studies are normally done by a reserve study specialist. It is not common for those reserve study specialists to be engineers or architects. That now requires that a reserve study specialist or their company have to work with or have to coordinate with the association to ensure that the structural integrity reserve study are actually completed, by an engineer or architect. The reserve study must identify the common areas being visually inspected. It needs to state the remaining expected useful life and replacement costs and provide a recommended annual reserve amount that achieves the replacement or deferred maintenance costs of elements being visually inspected by the end of the remaining useful life. So essentially, your structural integrity reserve study is similar to a reserve study that you would undertake for the other common element components of your association. The difference being that the structural integrity reserve study is focusing on the structural integrity of your building. Regarding reserves, the amount to be reserved for an item will be determined by the most recent structural integrity reserve study. Effective December 31st, 2024, members may no longer vote to waive reserves, to provide less reserves, or use reserves for any purpose other than for their intended purpose for the following items. So if in the past where the association was able to get a vote of the owners in order to waive reserves, an association is no longer eligible to waive reserves for the roof, for the load-bearing walls or other primary structural members, for the floor or foundation of the buildings, for the fireproofing or fire protection systems, for the plumbing or electrical systems, for the waterproofing and exterior painting of the building, or for the windows, or for that matter, for any other item requiring replacement or repair that exceeds $10,000, and the failure to replace or maintain that item would negatively affect any of the items above, as determined by a licensed engineer or architect. Developer-controlled associations may no longer vote to waive reserves or reduce the funding of the reserves. And associations that fail to complete a structural reserve study or the mandatory milestone inspection will be in breach of the officers and directors' fiduciary relationship to the unit owners. So there is now a tie-in between the director's breach of fiduciary duty and their failure to move forward with a structural integrity reserve study. A copy of the reserve study is considered an official record. As with the milestone inspection, it's open to inspection by association members and their authorized representatives, and it also must be kept by the association for 15 years. As additional requirements for Senate Bill 4D, on or before January 1st, 2023, condominium and cooperative associations existing on or before July 2nd, 2022, must provide information to the division in writing, by email or mail, including the number of buildings on the property that are 3 stories in height or higher, the total number of units in such buildings, the address of such buildings, the counties in which the buildings are located. Any changes to the above mentioned information within 6 months after the change must also be provided. Prospective buyers and lessees are entitled to receive a copy of the inspector prepared summary of the milestone inspection report and the most recent structural integrity reserve study. So with regards to tenants or renters, while we are aware that they have the right to access the declaration, the bylaws, the articles of incorporation, and the rules of the association, they are now also entitled to receive a copy of the inspector prepared summary of the milestone inspection report, as well as the structural integrity reserve study. So those documents are open to everyone who resides within your building. That is a summary and recap of Senate Bill 4D and the changes to the most recent changes to the Florida statutes. Thank you so much, everyone, for joining us this afternoon. We appreciate your time this afternoon. We hope you have a wonderful rest of your day.
Thank you for watching. Be sure to subscribe to our YouTube channel and visit our website at siegfriedrivera.com.